Hello. Thank you for joining me today. My name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. Thanks for taking time out of your schedule to talk about the project, the Southeast Supply Enhancement Project, and joining us for this webinar. So with that being said, we're going to go ahead and get started. I'm going to share my screen. Should be about a half hour today. If you have any questions, we can address them at the end. Thanks. So real quick, just an introduction on who I am, what we're doing, who I work for. I'm with the law firm of Seaver Walker Paget. We are a eminent domain only law firm, and we are a landowner only law firm. We are not with the pipeline. We do not work for Williams. We are an only landowner law firm. So we help landowners that are faced with pipeline acquisitions. We also help folks that are affected by power line acquisitions or road acquisitions. Any eminent domain scenario that landowners can find themselves in, we help landowners out. So I want to get that out of the way up front, because sometimes when people see our letters, they might be a little confused about who we are, what we're doing, and whether we work for the pipeline or not. I just want to say again, we do not work for Williams. And we are here on behalf of landowners looking to help out landowners affected by this project. What we're going to be doing today is we're going to be talking about the project, a little bit about the Southeast Supply Enhancement Project. We're going to be talking about eminent domain, but most importantly, we're going to be sharing our experience because we do this so often across the country, not only in North Carolina, but we have an office in North Carolina, we have an office in Georgia, we have an office in Indiana, Illinois, Ohio, Missouri, Texas, and we've helped folks out from as far away as Oregon. We do this all over the country, wherever landowners need help, wherever projects are being built. We are there to help landowners out with their eminent domain acquisition. So as a consequence, because we do this so often in so many different states, we see all types of situations. We've seen pretty much any situation you could think of with regards to an eminent domain acquisition, specifically with utility acquisitions, pipelines, power lines. We've seen pretty much every type of acquisition you could think of. And as a consequence, we've learned quite a bit. We've learned all sorts of interesting information about how these processes go. We know how these processes work. We know how Williams operates. We know how pipelines operate generally. And so we're here to share that experience so that when Williams comes through, and for those that don't know, Williams is the name of the pipeline company that's tasked with building this project. So when they come through and they start making offers to landowners and they start making an offer to you, the landowner, you'll be educated. You'll know how to handle it. You'll know what to do, what to look for, what to avoid. So with that being said, we'll jump in. So real quick about the project. So the Southeast Supply Enhancement Project it's a significant project. It's stretching along an existing transcontinental pipeline, Transco, as it's referred to, from Alabama up into North Carolina and Virginia. But the project itself is really I guess the meat of it is occurring in North Carolina and Virginia. Most of the rest of the project is working with smaller work just along the pipeline existing right away. In North Carolina and in Virginia specifically, though, they are adding new pipeline that's going to be adjacent to existing corridors. In North Carolina specifically, it'll be in Rockingham, Guilford, Forsyth, Davidson counties. They're also building compressor units in Cleveland, Iredell, and Davidson counties. So even though it is a significant project affecting quite a bit of miles of pipe, they're really only adding new facilities that require new easements, new acquisitions in North Carolina and in Virginia. Because this is a natural gas, and this is a map, of course, of the project right here that you can see. Because this is a natural gas pipeline project, it is governed in an interstate natural gas pipeline project. It's governed by the Federal Energy Regulatory Commission. So this is a federal project, requires federal approval. And the Williams filed their FERC application in October of 24, their application basically to build the project. So in order to build this project, they need to get approval from the feds first. And they submitted their application in October, seeking to get that approval. They are expecting their approval of this project in February of 2026, so next year. And the reason why we're talking about this is because with that FERC approval, they get eminent domain authority. Eminent domain authority is the ability to acquire your land, whether you like it or not. So assuming this project gets FERC approval, and assuming at that point you haven't reached some sort of deal with Williams, then they will go ahead and file a lawsuit against you in federal court to acquire the easement that they need from you. And we'll talk about that process in the next slide. But that's why we're talking about this. That's why it's an eminent domain situation, although it isn't yet because they don't have this authority yet and they can't quite utilize eminent domain. It's expected that they will get this authority from the approval. Now, I want to stress that if you're a landowner who's seeking to stop this project or doesn't want it to happen, I would say that the time, first of all, we are not here to deter people from launching that fight. If you are against this project, which a lot of landowners generally are, by all means, exercise your right, vocalize your disapproval. But the time to do that is not at eminent domain. You don't want to wait until you get sued in federal court and say this project shouldn't happen, because you will not win that fight. Very difficult to stop an acquisition at eminent domain. If you're looking to stop the project, the time to do it is now at the FERC process. You can jump onto the FERC docket. You can access it online. It's on the FERC website. You can file as an intervener in the process, in the application process, and voice your opposition at that point. So presently, now would be the time to go to FERC and say, we don't want this thing to be built. So just as an FYI, if that's what you're looking to do, that's where I would advise that you do it. So let's talk about the eminent domain process. So this is, again, assuming the project is approved, assuming they are granted this authority, which we are expecting them to get, assuming the project is, if the project is approved, they get the authority. So we are assuming the project is being approved. If it doesn't get approved, then they can't utilize eminent domain because they can't build the project. But we are going to assume that it is, and then talk about what happens then. So prior to filing a lawsuit, they will issue an offer to the landowner. Some of you might have already received an offer from Williams. That is a necessary predicate step to filing a condemnation action. If you have not received an offer yet, you're not missing anything. You're not, I wouldn't be concerned or worried. The reality is if that Williams wants your property, if they want an easement from you, and we'll talk about what that is here in a bit, if they want it, they will let you know. They are not going to be strangers about being around trying to get that easement from you. It is a situation where if they want it, you will absolutely know, and they will make their presence felt. So just because you haven't received an offer yet, that doesn't mean that you're missing anything or you need to be concerned about eminent domain or anything like that. Ultimately, if they need your land, they will let you know. The reason why you received a letter from us is because we looked at the maps on FERC, and we had our mapper go out and determine which parcels appeared to be affected by the project using GIS, publicly available information to see who the landowners were, and we sent mailings out. So that's why you received a letter from us, is because according to our research, again, we don't work for Williams, so we don't have access to their information. But according to our research, your property is in the path of the proposed pipeline in North Carolina. So that's why you got our letter. But ultimately, if they want your land, you will know, they will reach out to you, and they will be very present in trying to get that. If you never receive an offer from them, then they don't need it. and they did not need your property, and then they decided maybe to take a different route, or maybe our research wasn't perfect and your property wasn't affected. So either way, I just want to let that be known, because I know a lot of people probably haven't gotten offers yet. So moving on, you got the offer. There is some level of negotiation pre-suit, and then ultimately, if a deal can't be struck, they need the land, they need to build the pipeline. They will file a condemnation lawsuit. Again, this is after approval from FERC. In federal court. I say likely to use federal court because it's very likely that they will use federal court. They could theoretically use state court with this authority, but generally they pipelines prefer the federal court, federal procedure, because it's more friendly to to pipelines. State court has some statutory restrictions that federal court does not have, so I would expect that in this scenario they would file their lawsuits at federal court. Ultimately, when they filed their lawsuit, the lawsuit is over two things. It's over getting the land, first of all, from you, and how much compensation you're entitled to, how much just compensation you're entitled to for the acquisition of your property. Just compensation is guaranteed by the Fifth Amendment, the United States Constitution. So you ultimately, what that means is you're entitled to what, if it gets to that point, what a jury says you're entitled to. It isn't necessarily what they say you're entitled to. It isn't necessarily what you say you're entitled to. Ultimately, if it gets all the way down the road, a jury will hear evidence, and you'll present evidence, and they'll determine what you get. But I should note that you are not entitled to a jury trial in federal court. You could get a jury trial, but you are not entitled to one. You could get generally federal pipeline cases are heard before a commission, a panel of judges, or just the judge themselves. You could get a jury trial, but generally they don't impanel juries I'll just say rarely do they impanel juries on federal pipeline cases. So you are entitled to a trier of fact to hear your evidence on just compensation, but not necessarily a jury trial. So that's a beginning to end. I will also say that most of these cases do not reach eminent domain, and most of these cases don't and of those that do reach eminent domain, even a smaller percentage actually reach a trial on compensation. Most of the cases that we handled are resolved pre-suit without getting to condemnation. So that's something to keep in mind, something that, that's something that we've seen in our practice. So let's talk about what Williams wants from you, this offer that I've referred to several times. So they want an easement. And for a lot of you, you might already have an easement on your parcel. It's possible that Williams might have an easement on your parcel already. And some people don't know that. Some people do. The easiest way to know whether or not you have a pre-existing easement on your parcel is to go down to the recorder's office, go down to the deeds office, and ask for any easements that might exist on your parcel, and they'll be able to provide that information for you. So you might already have one on your property, and they might be looking for more easement in addition to what they already have. Some of you might be getting a brand new easement. You didn't have one. This is a brand new one. Because they're co-locating this next to an existing pipeline, I would suspect that quite a few people have existing easements on their property for a pipeline that already exists. It's fairly common for pipelines to put their new pipelines right next to existing ones. So something to consider about whether or not you have an existing one or not, because that will affect your case, whether you already have a pipeline easement on your property. So what is an easement? I've already said that word a dozen times. I haven't said what it is. An easement is effectively a deed, but instead of selling the entire land in a traditional sale, for example, you sell your house to your neighbor, they buy a deed from you. They buy the entirety of your property. They buy your home. They buy your land. They own it. You don't. That's a traditional sale of property. An easement, though, is you're just selling the right to do a certain thing on a certain area of your property. So if you have a pipeline easement that they want from you, they are ostensibly they're buying the right to build a pipeline on an area of your property. And that's a pipeline easement. Uh, so another way to look at it is if you sell your land and your property in a traditional sale, you sell 100% of the entirety of the land. When you're selling a pipeline easement or a transmission line easement or some other easement, you're selling a certain percentage of your land to a certain area of your land to someone else. Depending on who you ask, that's a 70 to 80 to 90% sale of that land to someone else in percentage terms. And that's putting it rough, but that's generally how it's viewed. So one question I get a ton is, what will the pipeline be able to do on my land? What will I be able to do on the easement area? So for example, will I be able to build fencing? Will they be able to knock down trees? Will I be able to build a home? Will I be able to farm over the easement? Will they be able to exclude me from the easement? All of these questions, whose rights exist on the easement area, and what rights are you relinquishing on that easement area? And some variation of that question, I get it all the time. And the answer invariably is it all depends on what the easement says. The easement is the document that will govern the rights of both you and the pipeline in that area. So it's important to keep that in mind, because what is told to you by right-of-way agents during negotiations, what Williams will present to you and try to convince you of what their rights aren't necessarily what the actual rights are, because it all depends on what the easement actually says. The document that they want you to sign will govern, okay? And the verbal promises that Williams might make during negotiations mean nothing as to what their rights are. The only document that matters is that easement, because that will govern what they can do. It'll govern what you can do on that easement. Some pitfalls that we have seen on easement documents, and this is fairly regular. I'm not going to guarantee that Williams does this, but on pretty much every pipeline case, we see the easement that's presented by the pipeline is incredibly broad and incredibly in the pipeline's favor. These are some very common issues we see with the easements that are proposed to landowners. We see unfettered access quite a bit, and that means access across your entire parcel, not just accessing the easement, not just accessing from public roads. They'll ask for full, broad, blanket access across all four corners of your parcel. We see that. I see that 99% of the time with pipeline easements, where they say, oh no, we'll just access it from the easement. We're not going to trample over your land, your farm ground, your residential property. We're not going to do that. Don't worry about it. But if you look at the easement, it says they have the right to access from adjacent lands, and that means all of your land. So that's something. That's the second point, access to the entire parcel. We've seen no clause for future damages for crop losses. They say they come in down the road and they damage your property, and they say, well, it doesn't say we have to pay for it, so we're not going to. No clauses for proper ground restoration. It's imperative, and especially in agricultural property, that the ground is restored properly when they're done with construction, and that means segregating topsoil and subsoil. That means ensuring that the ground is level afterwards. That means taking out any debris that might exist, huge rocks that they might have utilized during construction. Ground needs to be restored properly, especially to avoid erosion, if that's an issue as well. It's important that you require them to do that, because they'll try to get away with whatever they can if you let them. Liability on the landowner for that should be transmission line problems. So you need to make sure that you don't shoulder any liability for something that they do on their easement. That's a big deal. And we've also seen the right to build more pipelines, the right to add power lines, the right to add solar farms, the right to add fiber optic cable, all within the easement that without further compensation for you. So another thing we see a lot on these easements is that they will add the right to add a pipeline, another pipeline, and another pipeline, and another pipeline, and as many pipelines as they want, not only within the easement, but outside the easement. And it will attach to the entirety of the land. And these are called blanket easements. And they are unfortunately very common. And they're called blanket easements because they blanket the property. And so even though they'll tell you during their discussions that we just need this swath of land right over here, don't worry about it, we're just going to put one pipeline in and we'll be done. But if you look at the document, it'll say, oh no, they can add 1, 2, 3, 4, 5, 6, 7, as many pipelines as they want. And some of you that might already have these pre-existing easements, it'll be imperative to see what that pre-existing easement says, because that pre-existing easement might already grant them some of those rights. Because the reality is that a lot of old easements that are that have been, that were drafted 100 years ago, that unfortunately landowners signed back then, they're valid forever. Just because they were signed in 1947 doesn't mean they're automatically an invalid easement. And so what happens is that ancient easements become modern easements, and then the pipeline that that is now defunct, but that bought an easement from your great grandparents, your grandparents back in the 40s, that easement gets traded around from pipeline to pipeline. Eventually, it ends up in Williams' hands, and then they use that ancient easement to add more pipes. So what you're trying to avoid is that problem for your future generations, because easements are forever. So what you sign today will become, whoever inherits this property, whoever you sell this property to, it will become their problem, whatever it is. So if you don't get proper assistance and get a properly drafted easement now, your kids might have to deal with them coming back in and dealing with the problems that you might have caused by not properly drafting this easement or getting it changed. Easements are forever. They stick with the property forever. You need to assume that it'll always be on the property. So if you're signing this document, you need to make sure that whatever you're signing is incredibly well drafted. All of the problems that Williams presents are taken out of the easement, and the protections are added in, so that not only do these not become a problem for you, but they don't become a problem to whoever you sell it to, whoever inherits the land down the road. So it's just very important that easement is carefully drafted. So we talked about an easement, ensuring that the easement is properly drafted. That's very important, but that's only one part of the equation. A big part, don't get me wrong. But the other part of the equation is the money. How much are they paying you for this property, for this land, this easement they want? Because rest assured, just as they're going to come in and very likely issue and try to offer a pretty poor easement, they're also probably going to offer a low amount of compensation, or not a proper amount of compensation for your property for what they're doing. So when they do this, and they come in, a proper full compensation package should have a proper price per acre for the land acquired, a proper payment for anticipatory crop or timber damages, payment for anticipated soil or ground damages, or a clause in the easement that requires them to remediate properly, a proper consideration of all damages, whether it's fencing, field tile, irrigation, compaction damages, soil mixing, debris, flooding, things like that. And then finally, it should include residual damages. And this is the biggest component generally of a compensation package. And residual damage refers to damage to the property as a whole. So if you have a 40-acre tract, it does not have an easement on it, and then they come in and they want to cut right through the middle of that 40-acre tract, and they'll offer you some land for the 3-acre easement they want, and that's part of it. But the other part of it is, how does that easement affect the other 40, or the remaining 37 acres, excuse me? That is referred to as remainder damage, residual damage, consequential damage, diminution in value. They're all the same thing, and they refer to how does this easement affect the entirety of the parcel. And that's a real thing. You are entitled to how pipelines affect the rest of the parcel. People, whether it's true or not, people don't generally like to be near pipelines, or whether the danger is real or not. They don't want to live near pipelines. They don't want to be near pipelines. So that not wanting to be there, not wanting to deal with whatever comes with the pipeline, reveals itself in a value reduction to the property. Generally speaking, people pay less for property encumbered with pipelines than property not encumbered with pipelines. The difference in what they pay is residual damage, and that you are entitled to as a matter of law. if you can prove it. So that's a big one. Rarely is it offered. Rarely is it mentioned by right-of-way agents. So just something that keep in mind during these negotiations, something that you are entitled to. And that's, of course, in addition to whatever payments are offered by the pipeline. Sometimes we haven't seen the offers yet on this this project. We will eventually, but we haven't seen them. Sometimes there are bonus payments offered by utility companies to make a quick signature. We'll talk about why those can be fool's gold. But these are all, this is what you should receive in addition to whatever is offered by Williams. So I want to talk about right-of-way agents for a little bit. So we talked about getting an offer, receiving an offer from the company, from the pipeline company. You're gonna, if your property is affected, you're gonna have to deal with a right-of-way agent. And right-of-way agents are contracted individuals. They work throughout the country. Their job is to come out and sell you on the idea of you selling your land to them. And because they're professionals that do this a lot, they've developed strategies, tactics that we see all the time. And again, the goal for them is to acquire your land for as cheap as possible. So no matter what you take away from this presentation, just remember what the motivation is from them and what they are looking to accomplish from you. And so anything you hear from them, anything that they try to tell you, just keep in the back of your mind is that they are not working for you. No matter what they say, they are working for the pipeline company. And that is where their bread is buttered. So keep that in mind. These are some tactics we've seen from them. They will try to make it seem like they're offering you a good deal in the form of 125 or 150% of fair market value, some higher than normal price per acre. Again, according to who. But beyond that, right-of-way agents love to have price per acre discussions because the more you're talking about price per acre, the less you're talking about remainder damage. And so, for example, if you have a 4-acre easement and they offer you $10,000 an acre and you say, I want 12, you're playing 12,000 an acre, you're playing into their hand because $2,000, you're talking about $2,000 over 4 acres, it's $8,000. Not a big sum of money. And for the pipeline, that's a great conversation that they want you to have because that doesn't mean much to them. That means they're going to win that negotiation. And the more you're talking about that, the less you're generally talking about how the property, how the pipeline's impacting the property. Because residual damage, for example, on a 40-acre tract that's worth $10,000 an acre, say it's a 10% impact or a 20% impact, then you're talking $40,000 to $80,000 in additional compensation for that residual damage, as opposed to the $8,000 discussion of price per acre. So just keep that in mind. This is something they want to do. Bonus payments. Again, this is to get you into a quick decision saying, hey, we're doing you a favor. We're offering more than we need to. Go ahead and sign or you're going to lose that bonus payment. This is, again, is to rush you into a quick decision, get you to sign something without looking at it, get you on board without examining the easement further. Watch out for that. You know, timber and crop damages, sometimes they'll offer them, you know, as kind of an incentive. And the reality is that you're entitled to that regardless. And so the fact that they're offering it is not actually an incentive because they owe you for trees they knock down regardless. They owe you for crops they knock down regardless. Remember, your ability to say no, it creates leverage. Your ability to say, I'm going to look at this, I'm going to talk to an attorney, that creates leverage for you. They want your land, and your ability to say no changes that dynamic. They might impress on you that you can't say no. You can say no. You absolutely can say no, and you should say no, or at the very least, you should talk to somebody before you respond. Verbal offers, we see this a lot, see it a ton. They love to make all sorts of verbal promises and say, oh, this is what's going to happen with the easement. This is what's going to happen with the construction, this and that. The reality is their conversation with you at the dinner table in 2025 means nothing for how that easement's going to look in 2030, 2040. Doesn't matter what they promised you back then. What matters is what the easement says. So, and what they say verbally, these verbal promises, they mean nothing. If they want to make an offer, they can put it in writing. We see lowering, raising offers. We see, okay, you got to take it by this date or it's going to go down, or if you take it by X, it's going to go up. These are all, again, tactics employed to try to get you to sign this paperwork sooner rather than later. Ultimately, if you aren't sure if it's a good deal, if you are sure it's a good deal and you just want a second opinion, all you have to do is contact me. I will look at it for free and I will give you my thoughts and I'll tell you what I think about it, and then you can decide what you want to do. That's a real easy way to handle this situation and avoid all the pitfalls, is just to get a second opinion, get somebody's thoughts on it who knows what they're looking at, knows how these things work, and can help you out. So with that being said, and we're almost to the end, we're getting running a little bit long, and then we'll take some questions. What to do when you receive an offer? So this is the model way of handling these negotiations. This is the way to maximize your return, maximize your situation, make it as good as it can be in a situation you probably don't want to deal with. First of all, insist that the right-of-way agent communicate via email only. Texting is also okay as well, or just purely letter writing. The reason why I recommend this is that it creates a record. That way, you don't need to worry about verbal promises. You don't need to worry about verbal offers and saying they did this. Say, I only want to talk via email. If you have an offer you want to make, you can put it in writing. You can put it via email so that there's a record that is created to hold them to it. So avoid in-person discussions, avoid phone calls. These are things they're going to want to have. They're going to want to talk over the phone. They're going to want to show up and talk in your dinner table in your living room and go over everything in person, where there's no record, there's no history of what's been said, what's been promised. So insist that they communicate with email only. Insist that they send the offer via email. That's important. Say, listen, you got an offer to make, you can email it to me and I'll look at it and I'll get back to you. What I tell people, and this is the response that I feel is appropriate, once you get that offer, say via email to the right-of-way agent, thank you, I will review this and get back to you in a week. The reason why this works is that you're giving yourself some time, giving yourself enough time. A week should be enough. You can ask for 2 weeks. You're not going to be you're not going to be putting them off by asking for a week. No one's gonna begrudge you. That they'll give you some time. If you give them a time frame that you'll respond to that isn't 2 months, then they should leave you alone. If you don't respond, they're going to keep bugging you. They're going to show up. They're going to knock on your door. They're going to harass you potentially. But if you respond and say, okay, give me a week and I'll get back to you, that will, A, give you time to do your due diligence, and B, again, get them off your back for a little bit so that they're not hounding you about this offer. And in the interim, on that week, during that week duration, you contact me, contact an attorney, whoever you're going to talk to, get another set of eyes on the offer, get an analysis, and then you can respond in that week period, and you've allowed yourself some time to review it, but you're not putting them off entirely. They're not going to, no one's going to be put off by a week. They'll be okay with that. They'll accept that. Even though they're going to want it as quick as possible, giving yourself a week will allow yourself some time to do what you want to do, while at the same time avoiding them bugging you, at least in the interim. Again, finally, avoid in-person discussions and negotiations. The last thing you want to do is have these verbal talks in person with them. They are not helpful. And then that's what to do when you get an offer, what not to do. Don't engage in negotiations without or discuss value before contacting an attorney. One thing that landowners love to do is when they come in and make an offer, they say, okay, we're going to give you $10,000. They're going to say, oh no, I want I want 20. And then you contact me and you say, well, how much am I actually entitled to? I say, well, this is probably a $40,000, $50,000, or $60,000 case. The problem there is you already told them what you take. So people, they love to jump in and say, well, I'm doubling the offer. That's got to be good. The reality is you might be underselling yourself. You might be shooting low. And what they do, what the right-of-way agent does, is they'll document everything you say, and they'll write it down, and they'll put it in their file, and their file will stick with you throughout the entire process, no matter how long it lasts. And they'll always know that you were okay with 20 at some point. So you're already putting yourself behind the 8 ball. And beyond that, there's a lot to this that you might not consider with regards to value that you might be entitled to. So Landowners love to jump in and start talking money. There's time for that. If you're going to do that, if you're going to handle it yourself, there is time to respond and put forth an offer, even on your own if that's what you want to do. I wouldn't recommend it, but there is time to do that. So, but if you are going to do that, give yourself some time, do your due diligence, and then respond. Don't react. Don't enlist an appraiser. Some folks think they need to go out and get an appraisal. I would not recommend that at all. A, because it's expensive. B, it might not be necessary. It shouldn't be necessary, honestly. Appraisers are generally only necessary unless you're at litigation, or in other words, an eminent domain. So I would not recommend going out and getting an appraisal. Don't meet in person. We talked about that. Don't take promises at face value. Don't assume their interests are your interests. They are not. Williams wants to build a pipeline for as cheap as possible. You want to get an easement that is properly drafted, and you want to make sure your compensation is sufficient as well. Don't make a rush decision. Again, a rush decision is usually a bad decision. If you're making a rush decision, it's very likely that you're not considering all the aspects you need to in your negotiations. But at the same time, don't ignore this altogether. When they come through an offer, they're gonna make it, and ignoring it is only going to exacerbate the problem. They're going to keep hounding you. They're going to keep bugging you. And eventually, if necessary, they'll file eminent domain, and then you're at court. And maybe you shouldn't be at court, but you'll be there anyway if you ignore it long enough, and they just will end up filing a lawsuit, and then you're not sure what you should do at that point. So it's not something that you want to leave on the shelf forever. It's something that probably deserves your attention immediately, the easiest way to avoid all of this is to enlist an attorney who can handle it, so that you don't need to. You don't need to worry about ending up in court if you shouldn't be there. You don't need to worry about it at all, really, because you have somebody who you've hired to do that for you. So with that being said, talking about hiring an attorney, the way our firm works, we operate on a contingency fee, meaning our firm is compensated based on how much more we get than what is offered by the pipeline. So, for example, if you're offered $10,000, you hire our firm, we get you $50,000. Our firm collects 1/3 of the $40,000 that we add to the case. So it is a contingent fee. We are only paid if we get more than what's offered, and of the more that we accomplish for you, we collect 1/3. Included in this is negotiation of compensation and negotiation of the easement. So we negotiate the easement, we negotiate the money, and our fee comes out of the additional money that we add to the case. In this scenario, you would have started at $10,000. You would have ended up at roughly $37,000. Over three times the original offer, without needing to come out of pocket. And that's one of the reasons why we do it this way, is that a lot of folks don't want to pay for attorneys, can't pay for attorneys, don't want to come out of pocket to have some attorney represent them in something they didn't ask for. This allows you to hire me or our firm without coming out of pocket. You don't need to pay me any money to sign a contract. You don't need to send me a check or anything like that. If you wanted to hire our firm, it's as simple as signing a contract, allowing us to go to work, and then our fee comes out at the end. One question we get a lot is that, what if you don't get another dime than what's offered? We don't get paid. We only get paid if we get you more than what is offered. So that's how it works. We do it this way. First of all, it incentivizes everybody towards the same goal, getting as much money as possible. And B, it allows some peace of mind to you that what we're doing is on your behalf, because what we're doing in our representation is also on our behalf. We are incentivized to get more money because every dollar we add is another 33 cents in our pocket. So that's how it works, and generally people like it that way. If, for example, you want another arrangement, a retainer agreement or a billable rate, we can absolutely do that as well. But we can have that discussion, of course. Okay, and this is my final slide, and then we will open it up for questions. Next steps, as soon as you receive an offer, you should hire an attorney. Until then, until you get an offer, there's not a lot to do. I would maybe do some research on the property to see if there's a pre-existing easement if you don't already know. That'll help you understand your property a little bit more. Again, that can be you can go down to the local county recorder's office, deeds office, and ask for any easements on your property. They will provide it. Until you get an offer, think about what you want, think about what your goals are to present to your attorneys. I will say that if you have a group of landowners that are affected, you and your neighbors, the strength of a group is immeasurable. If you have 10 landowners that are all affected, they're all the ability to say no to Williams. That increases everyone's leverage. If they're all with the same attorney, they're all in the same group. The leverage of the more folks in a group, the more leverage you have, the better results you can generally get. It isn't necessary to have a group, but the more clients that one attorney has, for example, the more leverage that attorney has, and therefore generally the better result for all the attorney or the clients that attorney represents. So with that being said, again, if you have an offer, go ahead and send it to me for review if you'd like. Again, I don't charge for those reviews. You will not get a bill from me. It's 100% free. You can email it to my email address right there, jordan@landownerattorneys.com. You can also text it to my cell phone, 470-869-1383. You can also fax it to 317-575-9943. And with that being said, I am going to open this up for questions. So please, if you have any, go ahead and put it in the chat. I'd be happy to answer. Okay, not seeing any questions. Give it a little bit more. Oh, I see you raised your hand. We're not gonna do talking. So if you could just ask your questions in the chat, I'll answer it that way. You can also ask them in the Q&A section as well. Okay, well, I'm not seeing any questions, which is fine. You made it easy on me. Oh, there we go. We got some questions coming in. Okay, so one question: we have an issue with a creek. How should this be handled? Well, that's an interesting question. It depends, of course, how the pipeline crosses the creek. I think that just as anything, it will require some care. It'll require some easement language changes. You might need a side agreement also for how they're handling the creek crossing and how it's going to impact that. That really is something that, again, it needs to be monitored, or at least, the language needs to be inserted into the agreement that considers the creek and how they're going to construct it. You'll learn more about what their methods are as you get into the process with the acquisition, how they intend on crossing the creek. That'll also be covered in the FERC process, the FERC regulatory process, because they examine water crossings as part of that application. So how should it be handled? It should be it's already something of your concern, which is good. And what you'll need to do is learn about how they intend on constructing across that to avoid any complications to the rest of the parcel and to the creek itself. So that would just require your monitoring and, if necessary, language in the easement that governs how they do their creek crossing to lessen the impact on the creek itself. Will this outline be an outline of this presentation be available? If you want a copy of this presentation, just shoot me an email and I will send it to you. We generally aren't going to make it available online. Like we don't publish it. But if you want it, just email it to me and I'll send it to you. Beyond that, this webinar will be on demand. It is being recorded, and it will be available on demand. So it'll be available on our website as well. We're going to put a YouTube link up after it's been converted and put up on YouTube. Beyond that, you should also receive an email that it is available on demand. And further, just by signing up for the webinar, you can access the recording of it as well. Can we expect damages from this in the form of compensation? Well, you should expect it. I guess you should expect it as a matter of course for yourself. The way damages are generally paid depends on the type of damage that's being sustained. If it's something that can be corrected via construction conditions, then you can ensure that their construction is done appropriately to avoid the damages. But ultimately, if they can't, then you're entitled to payment. Our motto is basically either fix it or pay for it. It's one of the two, and it depends on the type of damage you're talking about. Whether it's if it's knocking down a fence, then you're entitled to what's it going to cost to put up that fence. If you're talking about damage to the remainder, as in damage to the property's value, well, that's obviously a monetary compensation. I'll say that broadly, damages are handled usually in the form of compensation, more so in them correcting things. And that's usually something that's in your benefit. You don't generally want them to fix problems they cause. For example, knocking down fences. Probably don't want them rebuilding the fence because they're probably not going to do a great job, and they'd have no incentive to do a great job. It's probably something where you're going to want to get paid yourself and have somebody you trust go out and do it. Another question. From the plans, it looks like the gas line is crossing a building on the land. What would happen to the building? The building would be knocked down. Any improvements that the gas line, the pipeline goes through, it will be knocked down. That is something that's trees will be knocked down. If the trees are in the easement, trees will be knocked down. Any structures on the easement, they will be knocked down. And you, of course, are entitled to compensation for them knocking that down. Other questions? Okay, I'm not seeing any other questions, so not a problem. I'm sure if you have questions, if they come to you later, it's as simple as shoot me an email and I'll answer it. We do not, we don't charge for these. We don't charge for answering questions. Happy to answer them. Another question: is time on our side or theirs? Right now, it's on your side. The ability, again, and that's because they want this now. They want your easement sooner rather than later. So your ability to say no gives you the leverage right now. Now, eventually, time doesn't become on your side, and eventually, it gets to a point where they'll just condemn and take the land, and then you'll be stuck trying to fight it out in court, and that's when it's not on your side. So right now, it's on your side. Your ability to say no, your ability to keep them off your land gives you leverage, and they want it now, and you don't need to give it to them right now. So you not being able to give that to them gives you the leverage. So right now, time's on your side, but eventually that will flip. So I'd say towards the end of the year, as you get into next year, then time is no longer on your side. It becomes more on their side. Is there action on our part until we get an offer? There isn't really anything you need to do until you get an offer. If you'd like to see if you have an easement on your property to learn to just make sure that you don't, or make sure you see whether or not you have one on your property, or a pipeline. Usually, if you know there's a pipeline, there's an easement. So that could be something you could do, but until that time, there isn't a ton you can do. You're doing it right now just by being a part of this webinar. You're ahead of the curve learning about this. So you're doing your due diligence as we sit right now. Until you get the offer, there's not a ton you can do. They're not going to, reaching out to them is not going to help. Then it doesn't help you at all because then it demonstrates eagerness on your behalf, which might not work to your favor. So this is a type of area where you want to respond and not necessarily you can't do anything to force them to give you an offer, and they go at their schedule. If wetlands are involved, is it advisable to get regulatory groups involved to help with leverage? Well, so the wetlands argument would be before FERC right now. And this would be something that if you get Sierra Club or what have you involved, they would advocate at the FERC level about how the pipeline will affect the wetlands on your property. I don't know if that necessarily helps your leverage specifically from an individual acquisition level, because ultimately that would be a FERC fight that you can get them involved, but ultimately it might prolong the FERC process a little bit, probably not, given how FERC is now doing their environmental assessments, which is much different than how they used to do it. I don't think it's going to help your individual leverage specifically. But if that's something you'd like to get them involved so that you get better protections of wetlands during the FERC process, that's something where they could be beneficial to you. As far as your individual case for compensation, I don't think it assists one way or the other, increasing your leverage for a better deal, for example. Really, the leverage in the situation is your ability to say no, and that exists. That exists now. That exists whether you're part of a group or not. Part of an environmental group that's contesting at FERC, not part of a landowner group, such as the folks we anticipate representing. Okay. Well, I don't see any other questions, so we'll go ahead and end it. Thank you so much for participating today. Great questions, great involvement. We appreciate it. If you have questions in the future, do not hesitate to shoot me an email. Happy to answer them. Happy to assist as you guys need me. Feel free to reach out when you get that offer. If you have any other thoughts, let me know. Otherwise, thanks for stopping by, and have a good day.